Dear students, in this lecture we'll cover the topic of trial, not fully but up to an extent. We'll do the meaning of trial, kinds of trial, and then common steps. By these common steps it is sufficient for you to write your exam, and in further detail we'll deal with the topic later on. Now let's start. There are three stages of criminal process: investigation, inquiry, trial, which have been discussed in previous lectures as well. Now what is trial? Trial is not defined in the code, but it could be defined as trial is a judicial proceeding conducted always for an offense. Judicial proceeding, we are done with it. What does it mean? So it is a judicial proceeding conducted always for an offense where court applies judicial mind, judicial determination of cause or matter to ascertain guilt or innocence of the accused for the purpose of delivering judgment, that is either conviction or acquittal. So judicial proceeding is conducted for offense, and during judicial proceeding court apply judicial mind, judicial determination of cause matter to ascertain guilt or innocence, because he has to deliver the judgment. And once trial starts, it will end either in conviction or acquittal. This is the general rule. Exceptions are there, we'll cover in later lecture, but general rule is trial ends in either conviction or acquittal. Now trial is not defined in the code, but it could be defined as, the same thing has been bifurcated here. Trial is a judicial proceeding conducted always for an offense where court applies judicial mind, judicial determination of cause matter to ascertain guilt or innocence of accused. Third, for the purpose of delivering judgment. Hence, purpose of trial is to ascertain the guilt or innocence of the accused. Now, kinds of trial. There are three kinds of trial: summon trial, summary trial, warrant trial. Warrant trial happens in court of session as well as in court of magistrate. Summary trial, summon trial, they happen in court of magistrate only. Court of session, it runs from 225 to 237. Court of magistrate, cases instituted on police report 238 to 243, and cases instituted otherwise than on police report, meaning thereby complaint cases, cases which have not been instituted on police report. If you can remember the cognizable, non-cognizable offense bifurcation and those lectures, then you may get a better understanding also. And then 248 to 250 deals with conclusion of the trial. And then summary trials starts from 260 to 265. Summon trials from 251 to 259. So first warrant trial in court of session 225 to 237. Then in court of magistrate 238 to 250, and then summons trial 251 to 259, and then summary trial 260 to 265, and 265 onwards your plea bargaining, that is a different topic. Now we'll cover the steps which are common in all or more than one trial. These points are sufficient for you to write exam, and in detail we'll also do in further lectures. Now there are certain steps. Information to accused. Accused has to be informed. Session trial, magistrate trial other than police report, magistrate trial, police report, and then summon trial. Information to accused. So in session trial, section 266 talks of compliance of 209, 209 talks of compliance of 207 and 208. Now accused has to be informed of the material against him until unless he knows how he can defend his case. 207 talks about supply to the accused of copy of police report and other documents. Now highlight this. In any case where proceeding has been instituted on police report. If proceeding has been instituted on police report, then police will investigate the matter and submit the document. Then magistrate has to furnish the following documents to accused. Now you see 208. It says when in case instituted otherwise than on police report. So 207 is for when case is instituted on police report. 208 when it is instituted on case is instituted, otherwise then on police report. Okay, and then magistrate thinks that offence is triable exclusive by court of session, then he will furnish accused following documents. 209 talks about commitment of cases to court of session, which is triable exclusive by court of session. So when it appears to magistrate that offence is triable exclusive by court of session, what he will do? He will commit. Always remember one thing. When case is going from magistrate court to session court, it is committal, commitment. This term is used when court is going from magistrate court to session court. And when case is going from one magistrate court to another magistrate court, then it is known as making over. So 209 also says he will commit the case after complying with provision of 207 or 208 as the case may be. So matter first goes to magistrate court, and then magistrate C, whether it has to be dealt by court of session or magistrate court, and accordingly they pursue the matter. If it has to be heard by session court, then they will commit the matter, otherwise magistrate court will entertain the matter. So in case where proceeding has been instituted in police report, then magistrate will give to accused what? The police report. First thing is police report, then FIR, first information report, and then all the statements by virtue of section 161. We have covered 161 in previous lectures. Confession and statement, if any, recorded under 164. Any other document by virtue of 173 clause 5. Meaning thereby each and every document which police is submitting to magistrate court against the accused, all those documents would be given to accused. Then 208, it talks about statement recorded under 200 and 202. So if you remember cognizable, non-cognizable complaint cases and FIR cases, then you will realize that process starts from 200 to 204. Any statement or confession which is recorded by police under 161 or 164, magistrate also records the confession under 164 if required. Any document produced before the magistrate on which prosecution relies, all these documents will be given to accused person. Again, 238 talks about furnishing the information as per 207. In trial in magistrate court other than police report. In the provision of trial, nothing specific is there, but accused will be provided with the documents. In summon trials, 251 says accused is informed when he appears or brought before court. So summon trial matters are very petty issues, very normal and simple. They are not that grave. Trial in magistrate court on complaint cases, again it is not that grave, but graver than summon case. Then trial in magistrate court instituted in police report, it is graver than both these two. And session trial, the matters are graver than all these three. Most elaborated trial procedure is mentioned for session trial. Then discharge. This is how the stages goes. Information to accused, after that discharge. Now if you remember, I told you that when police report is submitted to the magistrate court, then magistrate, he hears the prosecution, accused, and looks at the matter and documents before it, and then he decides. Then he frames the charges. So two things are there. Okay, then he frames the charges, and after that trial commences. So trial commences when charges are framed. Now discharge and acquittal are two different things. Discharge and acquittal are two different things. Discharge happens when court thinks that there are no sufficient grounds or evidences to pursue the matter. Then court discharge. Court is discharging because sufficient matter is not there in opinion of court. Acquittal means prosecution and defense, they submitted their evidences and then prosecution failed to establish the guilt of the accused. Then he will be acquitted. So discharge is not the end of the trial, but acquittal is the end of the trial. So 227 says that after considering the record of the case, all the documents, police report, medical report, whatever documents are there, after considering all the record and hearing both the parties, court does not find sufficient ground for proceeding. Court thinks that there are no sufficient ground to proceed with the matter. Court will discharge the accused. Court will discharge the accused. If court does not discharge, then court will frame the charge. Language is same. After considering the record of the case, hearing both the parties, court finds sufficient ground for proceeding. Court shall frame the charge in writing. Similar thing happens in magistrate trial on PR. Same language, considering the record, hearing both the parties, court does not find sufficient grounds. Same, section 239. And then again 240, same language, it talks about framing of charges. When we see magistrate trial other than PR, section 245 says after taking evidence of the prosecution, magistrate finds no case. So magistrate will discharge the accused. However, in case of summon matter, there is a little difference. As per 258, summon case instituted otherwise than on complaint, then if permission is there from Chief Judicial Magistrate, then magistrate may stop the proceeding and release the accused. And if this has happened, then such stoppage, if made before prosecution evidence, then it will amount to discharge. So if you see section 258 in your Bear Act, underline this. The magistrate may, for reason to be recorded by him, means magistrate will record the reason and then he will stop the proceeding at any stage without pronouncing any judgment. And if such stoppage is made after evidence of principal witness has been recorded, then it will be acquittal. Otherwise, it will have effect of discharge. In any other case, it will has the effect of discharge. This is how 258 talks about power to stop proceeding in certain cases. The main difference is that somewhere some things are mentioned in one section, at somewhere they are not mentioned in one section but split it into two sections. Now 249 along with 245, discharge in magistrate trial other than PR. 249 talks about absence of complainant. What if complainant is absent? Complainant is not appearing in the court. Then court may discharge the accused. What are the requirements? Requirement is that complaint case is there, complainant is absent on the day fixed, offense is compoundable, and it is not a cognizable offense, meaning thereby it is not a cognizable offense, it is non-cognizable matter. Then magistrate in his discretion may discharge the accused. It is happening because of absence of complainant in complaint case only. But in section 245 it is happening based on these parameters. Now court, you must be thinking, or if not thinking then think about it, hearing both the parties. So court is hearing both the parties, prosecution also and accused also. Now when can court ask the accused person? So 313 is used. It is used throughout the stages. Court has the discretion to use 313. It allows court to ask accused question where accused can tell personally in the sense that it is not on oath and he can tell the whole story. He can narrate. The court will ask how you have landed in this problem, and then he will narrate his version. No oath shall be administered. It is not happening on oath, meaning thereby technically it is not an evidence. But these questions, these answers are taken into consideration by court. And what happens exactly? Not only on the basis of this answers, but based on the whole evidence, court decide that what could be the matter. If evidences are very weak and they are supporting or corroborating the version of accused as per 313, court can rely on that. So, for the purpose of enabling the accused personally to explain any circumstances appearing in evidence against him, court can ask any question at any stage, at any stage, inquiry or in any inquiry or trial, at any stage, court can ask without previously warning the accused. No warning is required. We are not going the detail. We'll do those details in further lectures. Now, then comes framing of charges. Okay, so accused has been informed, and then matter was brought before the court. Then court heard the parties and looked at the record, and court, if decide that yes, there is a case, then court will go for framing of charges. Otherwise, court will discharge the accused. Now, framing of charge. 228 says we have done it. 240, 245. This is to be remembered. 251. Summon cases. No formal charge is required. It is not a mandate. It is not a mandate to frame the charge in summon cases. After framing of charge, court will ask the accused, do you plead guilty? 228 says in session trial, after framing of charges, court shall ask to accused whether he is pleading guilty or not. In every trial it is happening. If he pleads guilty, then court may convict him, not shall. Suppose accused has pleaded guilty, court is under no obligation to convict the accused. If court thinks that this accused is pleading guilty under some pressure or something fishy is there, court will not accept the plea guilt. Court will not accept his guilty plea and court will proceed with the matter. Guilty plea, do not go by the words, terminologies, just understand that if he is pleading guilty and court is satisfied that yes, it is bona fide voluntary, then only court will convict him, otherwise court will not convict the accused. So 228 says after framing of charges, court shall ask to accused whether he is pleading guilty or not. 229 says if accused plead guilty, then magistrate may, court may, this is session, not magistrate. In court of session you do not have magistrate, you have judges there, court of session, session judge. Then 240 says after framing of charge, court shall ask to accused whether he is plead guilty or not. 241 says if accused plead guilty, then magistrate may. Okay, judges may. Discretion is there, no mandate is there. 246 says the same language, and 251 also says the same language. And 252 says that if accused plead guilty, magistrate may convict him. 253 provides that he can plead guilty by post or by pleader. These are the petty matters, mainly in cases of fine. So instead of appearing personally, he send it by post or by through his or her pleader. After plea guilty, if he is convicted, fine. If accused is not convicted, then court will proceed to take prosecution evidence. 230. If accused does not plead guilty or is not convicted on plea of guilty, because magistrate court has discretion. So if he either he does not plead guilty or he has pleaded guilty but court has not convicted him, then judge will start taking prosecution evidence. He will fix the rate and then prosecution will keep on submitting the evidences. Prosecution will also submit a list of the witnesses whom prosecution wants to send a summon through court. So they will make a list and they will give that list to court, and they will state these are the persons they want to be in court, and then someone will be sent to those people, and through their summon they will be called. Same happens when defense evidence comes. 242 says if accused does not plead guilty or is not convicted, same language, then prosecution evidences. Same here, evidence for prosecution is taken at the commencement of trial, because these are petty matters. So procedure is told in a different way because these are complaint cases. When complaint cases comes, as per section 200, magistrate then and there examine the complainant and witnesses if any. You can see section 200, you will find it there. Section 200, examination of complainant. When magistrate taking cognizance upon complaint, what he will do? He shall examine upon all the complainant and witnesses present if any. So this is being taken at the stage when he is appearing before court, because these are the matter instituted in a complaint other than police report. In summon 254, if accused is not convicted on plea of guilty, then court will proceed to take prosecution evidence. Then acquittal. Now you need to remember, this stage is available only in session trial. This stage is available only in session trial. So 232 says if after taking evidence for the prosecution, now prosecution has submitted the evidence and court think there is no case, okay, evidence for the prosecution, examining the accused, 313 used at this stage, also used at this stage, and hearing the prosecution and defense on the point. Now the judge considered that there is no evidence. There is no evidence. Then judge shall record an order of acquittal. No such provision is there is in any other trial apart from session trial. You must remember this. After prosecution evidence, then defense evidence. 233, if accused is not acquitted, then magistrate would ask the defense to furnish evidences. Okay. Accused may apply for issue of process. Now what happens here? Accused again want to cross-examine few witnesses, few or n number of witnesses, but if court think that that would defeat the purpose of the court, abuse of process of court, and he is doing it to delay the matter, waste of time, then judge and court will not allow it to happen. You have stage of cross-examination, you do it then and there. When witness is there, you cross-examine. After examination in chief, it's fine. But after that stage has gone and you have submitted the evidences, then court will not allow. Court will say that why you did not do it in the first place. But if court thinks that no, there is a serious matter or something different may come out, then court will allow. All of these things court learn from their practice, that's all. Here you can just listen and understand. They deal with the matter, so they develop that judicial discretion. They develop that judicial determination, judicial mind, judicial learning. Then 243 says after 242, accused would be called to submit the evidences. Now when accused is submitting evidences is defense evidence. He is submitting defense evidence. And then accused may apply for process, but same thing. If court find it to be waste of time, court will say no. 247 also follows same step as 243 in case of complaint cases before magistrate. Now summon cases, 251 says that when accused is appeared, he is asked to submit defense if any or plea guilty. This is 251 says, the difference of language and a little bit difference of provisions also. how they have been written in the coherence. Now if he does not plead guilty, he would adduce the defense evidence as per 254. So as per 251, when accused appears or is brought before the magistrate. Okay, so magistrate will tell the particulars of the offense, unlike 207 or 206, 207, 208, 209. When he is brought before the magistrate, the particular offense are to be mentioned told to the accused person, and then court will ask whether he plead guilty or has any defense to make. So he shall be asked. 254 says procedure when not convicted. Not convicted in the sense as per 252 and 253. 252 says conviction on plea guilty. If as per 251 he has pleaded guilty, then he will be convicted as per 254. 253 conviction in absence of accused party in petty cases. This is the section which I told you that he can get it done through post or by pleader. So procedure when not convicted, when he is not convicted, then he will take all such evidences as may be produced. Accused, and also to hear the accused and take all such evidences as he produced in his defense. This is how it goes. So same hierarchy is same, except that acquittal part, it is same. Everywhere there is information to the accused in the first instance, then the stage of discharge. If no discharge, then framing of charge, then plea guilty. If plea guilty, conviction. If does not plea guilty, then prosecution evidence, then defense evidence, and acquittal is happening only in the trial of session, court of session. And then arguments. 234 provides specific section. Now both the parties will sum up. You can understand this as happens in moot court rebuttal. You can create an analogy and you can understand it in that way. Both the parties, they will sum up their case, they will their summary of their case, they will submit it by virtue of arguments. No such provisions are in other trial, but as a matter of practice, inherent power are there with court. They can listen to the party and do accordingly. Enough power is there as per Evidence Act also. And then judgment will be delivered. So this part we are not doing. We'll do this part and other details in next lectures. This will be sufficient for your exam, because most of the time questions are being asked that what is the procedure in session trial or magistrate trial or similarity. This kind of things are being asked generally. Then opening of the case, obviously session court, when state is there, so prosecution will open the case. When complaint case is there, then private person is going, so private person can handle the case through private pleader. Court may allow that, not a big deal. And defense obviously will be having his advocate. Now in order to have bail, accused can get his pleader, his lawyer. And for state, this public prosecutor, section 24 CRPC, they will work, they will proceed. Withdrawal of cases is also there. This is happening in 257. Specifically provision is there, withdrawal of complaint 257. This also you must remember. What is happening here? It is happening that a complainant at any time before final order is passed in any court, and if he satisfy the magistrate that there are sufficient grounds for permitting him to withdraw his complaint. If he satisfy the magistrate, if magistrate is satisfied, then complaint will be withdrawn against the accused. Many times they realize later on, party realize later on that specific case is not there, or some issues is there with identification or similar thing happens, then they can satisfy the court. No specific illustration is there in this section, but these are the obvious reasons, and court then, if satisfied, allow to withdraw the complaint. Now these are happening in summon trial, which are petty issues in itself, so not much seriousness is given, because court can deal with these matters easily. They are not grave offences. Seriousness is given as per the gravity of the offence. The more serious the matter, more serious is, and more harsh is punishment. So hope this would help you. Will meet during further lectures. Best wishes.